All right. Good morning. Thank you so much for joining us today for this seems very timely and very interesting topic. Got some fantastic resources to educate us on this and give us updates and give us the current state of things regarding federal vaccine mandate. So thank you guys for joining. My name is Ethan Gill. I'm the president of Helios HR. We are the largest HR consulting business in the Mid-Atlantic, and really work with organizations during times of growth, times of expansion. And this has been a very, important and great time for HR practitioners and executives. And so lots of HR factors or topics going on right now, including this one from the vaccine standpoint. So thank you so much for joining us. We're pleased to present today's webinar in partnership with NFP. They are the 5th largest privately owned insurance broker in the country, and Holland Knight, a global law firm with more than 1,600 lawyers and other professionals in 30 offices throughout the world. Before we get started, I'd like to review some housekeeping items. First, we're recording this webinar, and we'll send you a copy in a follow-up email. So take notes, certainly if things stand out to you, and just know that you'll get this content as well as kind of the key highlights of the presentation of the discussion as well, for you to take back to your businesses. Again, we're really focused on providing content that can make a direct impact into the businesses and the participants of these events. If you have a technical question or a question for our panelists, you can type it into the Q&A box in your control panel at the bottom of the screen. At the end of our panel discussion, we'll open it up to Q&A and try to get to as many questions as possible. Sometimes we have questions that we don't have time for, but we'd like to try to follow up with those in the email format that comes, or the email that comes as a follow-up to this event. So we'll do everything we can to make this as valuable for you as possible. Another way we do that is we incorporate polls throughout the webinar. These have been fantastic opportunities to collect information about the marketplace. And so we will have, I think it's a couple questions on from a poll question perspective. The more participation we get in those, the better. And we, again, share that information with you to leverage within your operations or your organizations for that. Just a great way to kind of get a sense of where things stand in relation to those questions. So I'd like to now introduce my colleague, Jenna Lewis. Jenna is a management consultant with Helios HR. As a consultant, Jenna brings specialized experience in government contracting, compliance, and policy development while implementing strategies that attract, engage, and retain top talent, which obviously is a fantastic and important skill set in this marketplace as we know it right now. Jenna will be interviewing our employment law specialist, Ariail, with Holland and Knight, a partner with Holland and Knight for that. Kara practices in the area of employment law, counseling, and litigation, and is a member of Holland and Knight's government contracting team. She works closely with employers in a range of industries to provide ongoing counseling, training, and investigations designed to minimize the risk of litigation and maximize employee retention and productivity. She's a very, very important partner of ours and added a lot of value for our clients in the past. Of late, Kara has been extensively advising clients on workplace matters relating to the COVID-19 pandemic, including employee vaccination policies and legal requirements. We know how busy you've been recently, Kara, and so appreciate you being with us here to share your insights with us. With that, Jenna, the floor is yours.
Perfect. Thank you, Ethan. And thank you, Kara, for joining us today. We are very excited to have you here. I can say I've been to a few of Holland and Knight's recent webinars that you've spoken on, and they are incredibly informative. So just very excited for you to share your time with us today. So what we're going to cover today is where we are today with this mandate, what's ahead, our next steps and considerations, and then at the end, we'll have some time to take some questions from our attendees. And hopefully we can get through all of those, but anything we don't get through, we'll follow up with you. So to kick things off, we are going to start with a poll. So if you can take a second and review the question, how prepared are you for the federal vaccine mandate when it goes into effect? So you've got a couple different options: very prepared, somewhat prepared, not yet prepared. So we'll wait just a second so you have a minute to answer. Kind of see those coming in. And that'll help kind of guide our conversation today. So Appreciate the responses so far. I'll give you a couple more seconds. It looks like we're almost there. Perfect. So it looks like for the most part, we've got either very prepared or somewhat prepared. So hopefully for those of you who are somewhat prepared or not yet prepared, we can answer some of those outstanding questions for you today. Perfect. So to start off, our first question today, Kara, if you can just give us a brief overview of the employee vaccination requirements, the timeline of how we got to where we are today, and some of those related developments.
Sure. And thank you, Jenna, and also Ethan. It's such a pleasure to be here. Helios and NFP are fantastic and longtime business partners and trusted collaborators. So I'm happy to have this opportunity to present to everyone. It's certainly a topic I've been advising on pretty much nonstop for the last couple of months now. So hopefully we can provide some good content and answer everyone's questions. In terms of where we are at now, there's a lot of confusion, quite frankly, right? Because for a couple reasons, partly because there are new developments every day, right? Whether it's updated guidance or, state level or private challenges that are emerging. I think there's some confusion with the OSHA standard that recently came out as well. So I think it can be really hard to kind of parse out exactly where we are. But the bottom line is that following on President Biden's executive order mandating vaccination for covered federal employees, the Safer Federal Workforce Task Force implemented guidance. The Federal Acquisition Regulation Council did prepare a contract clause to be incorporated in certain contracts. And where things stand right now is that the compliance deadline for the vaccination mandate under what I'm going to refer to throughout this presentation as the Federal Contractor vaccine mandate, that's kind of my shorthand. The current deadline is that by January 18th, 2022, all covered employees need to have either verified their vaccination status with their covered contractor employer or obtained and been approved for an exemption on the basis of religious beliefs or medical conditions. And so that January 18th date, it's been a little bit of a moving target. We started with December 8th as the compliance deadline, and that recently has been shifted. In terms of what that means, we're talking about full vaccination, right? So that means 2 weeks have passed since covered employees have received their single shot in a single dose series or their second shot in a 2-dose series. And at this time, despite all the legal challenges that are ongoing, that mandate remains in effect, right? And I think that's an important guiding principle because generally what I've been telling employers is that you should be working with an eye towards compliance. It may be that some of these challenges are effective and some of the deadline changes or the parameters of the requirements change. That all kind of remains to be seen. Certainly, there's at least one injunction right now in the states of Kentucky, Ohio, and Tennessee prohibiting the federal government from enforcing the mandate, even though we're way far ahead of the deadline. But in general, compliance is still the objective here, and the compliance date right now is January 18th. So that's really where we're at, and I think how contractors should be viewing this. At the same time, and I think this is another important guiding principle for this conversation, while we want to be working towards compliance, there is no reason to create risk that may ultimately not need to be created, right? And so what that means is if we're talking about internal enforcement, taking adverse action against employees who are not in compliance with our own internal policies, denying accommodations and taking adverse action in connection with that. These kinds of decisions create risk for employers. And I'm recommending that we try to slow roll these decisions. Leave yourself the options that you need to address these things a few weeks from now, maybe even a month from now. Make sure that your messaging is open enough that you have the flexibility to make those decisions at a later point. But in general, consider whether you really want to start taking decisive action that then triggers risk. And mainly, I mean, essentially terminating employees who aren't in compliance or who can't be accommodated. So with those two principles, that's really going to underlie everything we talk about today. And I think any advice that I provide in terms of questions. Another important thing that's noted on the timeline is that we've not only seen continuing emerging task force guidance, and updated Q&As. But at various points, we see that the EOC has provided a little bit of guidance on the religious exemptions. As we'll discuss later, I didn't find it super helpful, and I'll explain why. And then we're also seeing, that with this OSHA standard, that had some particular details and guidance and expectations for employers that, while not applicable necessarily to the federal contractor mandate, I think is helpful, and it's something that we can all kind of look to for some ideas and information. And Jenna, I want to stop on that point for just 1 minute, because I think there's some confusion around this. The OSHA Emergency Temporary Standard has been temporarily stayed, both by OSHA and by a Sixth Circuit injunction, and while waiting for a consolidated legal challenge from several states. So right now, that standard will not be going into effect in early December as was originally anticipated. But more importantly, I want to make sure everyone is clear that the OSHA standard does not apply to covered contractor workplaces under the federal vaccine mandate. And in addition, it does not apply to employees who work completely remotely. And so what I'm finding in terms of how this plays out is that for most of the government contractors I work with, unless you maintain a separate commercial line of business that is run out of a separate physical location, for the most part, government contractors who do not have those things in play are not really going to have to be worrying about complying with the OSHA standard. And that's because if you don't have those segregated workplaces and those separate commercial lines of business, then all of your work sites are going to be covered contractor locations. And then for your remote employees, whether or not they qualify, they're still not going to be covered by OSHA, because those standards about testing or vaccination won't apply to remote employees. So I just wanted to make that point clear at the outset, because I think it's been very confusing.
Yeah, I think that's a great point to call out, because we've gotten a few questions too. Do they both apply? How do they coincide? So definitely appreciate you calling that out as well. Which actually leads me into our next question. So as far as coverage, so who does this apply to? Do all federal contractors fall under the mandate? How does that look?
So it is not all federal contracts. There are some distinctions, for example, for contracts that are just for products versus providing services to the federal government. But it's a pretty broad mandate in that it covers certainly all service contracts, right? And it covers most federal contracts that are not exclusively for products, and then also extends to subcontracts on those contracts. There's a flow down obligation. So if you are a prime contractor, you have to flow down the vaccine clause that's in any of your covered contracts to your subcontractors. If you're a subcontractor, you can expect that vaccine clause to flow down to you. And so when we're talking about when coverage essentially is initiated in these covered contracts, we're looking at any new contracts that are awarded on or after November 14th. So the deadline has already passed. And then in terms of contracts that were awarded between October 15th and November 14th, essentially wherever the agency exercises its option, its right to apply the requirement and modify the contract to include the clause. And then any existing contracts that are in play, if they're extended or they're modified or they're renewed at any point now, then we're going to be dealing with the clause in those contracts as well. And I think this is also an important thing to really understand, because this January 18th, our current compliance date, is the date that, to the extent that you have a new contract or you have a contract that's modified prior to that time, you're going to have a little bit of lead time for compliance, right? But in terms of any contracts that are modified or entered into after that point, you may have less lead time to come into compliance, because it's going to be the effective date of performance that vaccination requirement applies. And so for your planning purposes, I think as a government contractor, this is important, because you may not have any covered contracts now, but I think there's still value in considering where you're at, right? Looking at all your contracts, what are the opportunities or expectancies in terms of extensions and modifications? And we are even aware that some of our clients have had their customers modifying contracts just for the purpose of adding this vaccine clause. So I think it's a business decision that needs to be made. We've seen some employers have had pretty open dialogue with their government customers and the customer said, yes, we are planning to modify this, or no, we're not going to take any action before, the extension that comes up next spring, right? And so I think that to the extent that you have that ability to openly communicate, whether it's with your government customer, whether it's with a prime that you're subbing on, then that's a good next step. But in the event that you don't get that clarity, just kind of being prepared and anticipating that it's looking like January 18th or at any point thereafter where the contract is modified. And again, I want to step back on that for a moment too, to make sure everyone understands exactly how this is implemented. Although the executive order was issued, and although the task force was directed to develop guidance implementing that executive order, the enforcement and the implementation vehicle here is a contract clause. And the FAR Council developed a contract clause that I'm shorthanding it, but essentially it says you need to follow the Safer Federal Task Force guidance, right? That's the shorthand. And so all the requirements that are set forth in the guidance will apply here. And I think it's helpful to understand this both in terms of messaging to your employees and in terms of thinking about how some of these other conflicting points, right? State laws that are coming out. We'll talk about the one in Florida, for example, some of these legal challenges, like how these things are really being framed. Because from the federal government's perspective, this is a contract compliance issue, right? They have the right to negotiate terms of their contracts. The federal government's position is that it's perfectly appropriate for them to modify contracts to include provisions that ensure productivity and continuity on the contract by minimizing, people contracting COVID-19 and the impact that would have on the fulfillment of the contract. And so this is not a law per se, right? This is not a law that the federal government is imposing on people. There's no requirement by the federal government that anyone has to get vaccinated. There is no requirement technically by the federal government that any government contractors need to comply with these requirements. From the government's perspective, it's a matter of if a federal government contractor wants to do business with the federal government, this is a condition of doing business. And taking that down a step, the requirement is not that federal contractors do any particular thing, right, with their own employees, right, in terms of enforcement. So the government's going to say, you can't work on or in connection with a contract, or you can, we'll talk about this too, or you can't work in a covered location unless you're in compliance. But we're not telling federal government contractor employers what to do with their employees. We're just saying you can't work on our contracts. And I think that's going to be a really important point if and when we get to enforcement, because the idea is going to be, you're not going to be terminating anybody. You're not going to be letting any of your employees go because they're not vaccinated. You're not going to be forcing any of your employees to get vaccinated. The deal is that you are not going to be able to employ them on your federal contracts or in your workplaces where these federal contracts are being worked on. And as a result, if you don't have anywhere else to put them, then you'll have no choice but to remove them, right? That's really the framework we want to be thinking about, because I don't think it's appropriate or certainly ideal from a legal risk management standpoint to take the position that we're making employment decisions based on employees' vaccination status. We instead want to frame it as a two-step process. The employee can't perform the work that you need them to perform. You're going to evaluate whether there's anywhere else you can put them where they are able to perform. And only after you've completed that second step are you going to make decisions about adverse actions and removing the employee.
Right, and I think you touched on something that leads us directly to our next question. And when you say in close connection with, so I know in the past there have been some 80-20 rules where, if 80% of your work is done on the contract, this applies to you. That does not appear to be the case with this particular mandate. So if we can talk a little more about what does that mean? Who does this apply to? What is in close connection with? I think that would be helpful.
Absolutely, and I apologize. I keep getting a little bit ahead of myself on this slide. Yeah, you're absolutely right. We are used to seeing this 80-20 rule, and it's not in the guidance. It is notably absent, I would say. And so we don't have perfect clarity or just definitive clarity on what this means in terms of an employee working in connection with a covered contract. But the way that Holland and Knight is interpreting and understanding that is that essentially, if you have an employee who's indirectly touching the contract in any way, right? Like any admin role, any business development role, any operational role. You note on the slide, like the overhead pool, right? Anyone who's working on the contract, regardless of how much or how little, the guidance would suggest that those individuals would be covered. And so absent more clarity, that's the position we're taking. And we know it's because the mandate is intended to be extremely broad. It's intended to cover as many employees as possible. And so when you look at the three categories that are laid out so nicely here on the slide, I mean, you really do end up getting pretty full coverage. You get any employee who's working on a covered contract, right, who's billing to a covered contract, and that's going to apply even if the employee is entirely remote. And that's an important point. So if you have an employee who's billing on a contract, they never go onto your customer site, they never come into your office, they're working from home, they are still subject to the vaccine mandate. Now, for employees who are working on or in connection with a covered contract, that is going to come into play in terms of whether or not they also are going to be vaccinated, even if they're working remotely. And then the third category, and this is the tricky one, and the one that I think is so broad, is the requirement also applies to any employee who's likely to come in contact with someone who's working either on a covered contract or in connection with the covered contract. And what I think this means from a practical standpoint is that if you have any employees who don't fall into these first two circles, but they're still coming to a work site that you control as the contractor, where employees who are either working on the contract or in connection work or are likely to be, then they also are going to be covered. And just to play that out a little bit, that would include not just working, in the same office suite, right? But if they're working in the same building and they're going to be sharing the same restroom or the same break room or the same parking garages, it's a very kind of broad definition in terms of the covered contractor workplace. Further, I've been talking to some employers who, maybe they have a location in Seattle, right, where they perform commercial work, but the executive team visits there once a month. And the executive team is going to be covered in terms of working in connection with a covered contract. That then those employees who work in that office would be deemed likely to come into contact with covered employees, even though they don't work with them on a regular basis. So it's really intended to be very broad. And as I mentioned before, I think from a practical standpoint, the only employees that are likely to be excluded are employees who work completely remotely doing non-government contract work, either direct or indirect. And then to the extent you maintain any facilities where you can confidently ensure that no covered employees will be accessing or visiting, then potentially in that case, you could also have an exception for employees who work at that facility.
Yeah, so very, very broad, I think is the takeaway there.
Yeah.
So I think that'll bring us to our next poll. If we can go ahead and launch the next one. So in this one, we are looking to understand what the biggest hurdles are for you or for your company in regard to complying with this guidance. So we have things like tracking employee vaccination status, reviewing your exemption requests, determining the accommodations, what to do with employees who don't comply and don't have an exemption, or other, the nice broad category of other. So if you can take a second and respond to that. It looks like we're at about 50% participation. So I'll give you a couple seconds to review and respond. And we appreciate all the responses. So thank you to everyone who's participating in the polls. It is very helpful for us. Looks like we're getting close to 80%. So I'm gonna go ahead and let you all know how that turned out. It looks like the biggest hurdle so far is reacting to employees who don't comply and the accommodations. So again, perfect segue into our next topic. So Kara, I think we're gonna move on then to requests for exemptions from the vaccination requirements. So whether that's religious or medical, and I feel religious is a little more vague, how to handle those exemption requests. And then once we handle those, if someone does have an approved exemption, what kind of accommodations might apply for those people?
Yep. And so let's talk about medical first, because I think that is a little bit more straightforward. Just like with your typical ADA accommodations, and let me say this is a little bit broader. It's medical conditions is the terminology used, which suggests something broader than an ADA covered disability. But just like those accommodations, you can ask the employee to identify the medical condition that prevents them from complying with your policy. And you can ask that they provide information or certification from the healthcare provider confirming that provider, that is their medical assessment or opinion that the employee should not be vaccinated for a medical condition. So I think that, as we're looking at accommodations in general, we want to think about what our objective is, right? At a minimum, our objective should be protecting the employer, making sure we kind of minimally have complied, minimally can demonstrate that we haven't just rubber stamped every accommodation request, but that we've made sure that we have kind of a baseline for approving these exemptions. And so I think that's sort of your floor. And then really your ceiling is how aggressively do you want to pursue it or challenge it, right? We have some employers that want to be the test cases before the EEOC, right? And are very comfortable with that. We have other employers that are like, please, I only want to do the absolute bare minimum that I need to do to protect the company. And there's no right or wrong answer. It's all kind of tied to your tolerance for legal risk. And I think your objectives, your operational objectives, which sometimes can really only be assessed once you have a sense of what you're dealing with, right? What percentage of employees don't want to comply? What sectors are they in? What contracts are they supporting? How is that going to impact you operationally from a continuity standpoint, from a rehiring and retraining standpoint? So it's a difficult decision sometimes, I think, to make in advance, and it's something you kind of constantly reevaluate as you go along. In terms of the religious exemptions, I've got to tell you, I have probably advised on, I'm not exaggerating, no less than 1,000 of these in the last couple months. So I've seen I've seen pretty much every example that comes up. But here's the minimum requirement. You want them, and this was clarified by the EEOC guidance that was issued as noted on the timeline. You want to make sure that the employee has established that they have an actual religious belief that's underpinning their exemption request, right? So it's not a political belief, not a understanding of the science, but a religious belief. Now, under Title VII, religion is defined incredibly broadly, and the bar is extremely low, extremely low. So a sincerely held religious belief does not have to be any organized religious belief, right? It can even be moral beliefs that are held with the conviction of traditional religious beliefs. It also can depart from a mainstream religious belief. And I'll give you the perfect example that I'm sure all of you are seeing. The Catholic Church has said, it's okay, you can get the vaccine, right? And yet over and over again, we're seeing these exemption requests that say, because I'm a Catholic or some other religion and I'm opposed to abortion, I can't take the vaccine because fetal stem cell lines were used in the research or production of these vaccines, right? That's one we're all probably seeing over and over again. And so that's just an example that really illustrates that just because the Catholic Church or other Christian churches have said, it's okay, this doesn't violate our beliefs, an employee can legitimately hold a belief that departs from that, even if they identify with that more mainstream religion. And so that's important to understand. The second piece is, as the baseline, you want to make sure that the employee has explained why the religious belief precludes vaccination, right? So, and I'll give you a little bit of an illustrative example of that. I'm seeing a lot of times that, requests where someone will cite the Bible and a verse that says essentially, my body is a temple and, means that I need to take good care of it, right? That kind of thing. But if the employee doesn't connect that belief to why they're not getting vaccinated, I'm encouraging employers to get a little more information. That's not really enough, right? Because the idea of the religious belief that my body is a temple does not necessarily mean that because of that, you can't take vaccination, right? You need the employee to make that connection on how their belief precludes it. So those are really the two pieces and the two questions that I think employers should be asking. Probably most of you already have a standard form that you're using, but if not, I think it's advisable to kind of develop a form or a process where you're asking the same thing to all employees so that you're treating everyone the same and that you're consistently requesting the same kind of information.
Yeah, just to echo that, I think you hit the nail on the head there. Consistency is absolutely key, especially with this sort of information coming in. And as far as accommodations, so if we approve an exemption request and we've decided someone can have an accommodation for this, what does that look like? Is it dependent on the contract, whether or not they need to go in person? I'm sure there are a lot of moving parts, but just a high level overview of
Sure.
accommodations.
So you're absolutely right, case by case basis, right? Like you would never want to take anything you read or hear from me or anyone else and just blindly apply it to every situation. But I think a really helpful way to look at this is to think of it as a two-step process. So the first accommodation request is the exemption, right? That's the first piece. And that's the piece that I do not think you should delay in evaluating. I think we want to get a handle now, right, on which employees are going to be exempt, which employees are not going to be exempt. But the way I'm encouraging employers to view it is that that's really the first step, right? The first part of the accommodation. Because even if you determine that an employee is legally entitled to an exemption and you can accommodate them by granting the exemption, that doesn't mean there aren't additional accommodations that will be required to allow the employee to perform their job. And so I think this is an area where, when I talked before about slow rolling certain decisions, I think this is a good area to slow roll in terms of you grant the exemption request and you make sure employees understand that you're still in the process of evaluating what additional accommodations they may need to perform their job. You let them understand that simply because they've been accommodated with the exemption, that does not necessarily mean that they can be accommodated in all the ways that will be necessary for them to continue working on the contract. And then you're going to wait, right? Like you're going to look at developments in public health guidance and customer requirements and law and all the guidance that we're receiving from the task force, because I think as more time passes, we are getting a little more clarity on that. But generally, the types of things you're ultimately going to be looking at are, if you have an employee that works completely remotely, probably no other accommodations will be needed, right? Because you won't have to worry about, testing or masking or other protocols. If you have employees that work on site or work on a customer site, then I think remote work is actually one of the accommodations you may want to be considering, right? And interestingly, there's a big difference, of course, in terms of what accommodations you can make, depending on who controls the employee's work site. So if the employee reports to your office, you're the one who has the control over the work site. You're going to get to decide, do we want enhanced safety protocols? Do we want testing? Do we want to have this employee work remotely? And you're going to be in control of that, and you're going to be able to make those decisions. If you have an employee who is working on a prime contractor site or on a government customer site, you're not going to have the same control. Now, the federal government will tell you over and over again that, it's not their decision. They're not deciding what accommodations you make, but maybe they're going to say, but by the way, we aren't going to allow anyone who's not vaccinated on this property for any reason whatsoever, right? I mean, we're seeing that start to happen. We're not going to allow testing. We're not going to allow remote work for your employees. So certainly we anticipate that there are going to be some situations where, employees may be properly exempted from your policy, but you may not be able to accommodate them because the customer may say, this role can't be performed remotely, and we aren't allowing anyone on our work site who is not vaccinated. And then that's going to put you in the position of saying, okay, now we can't have this person performing on the work site, going through that analysis. Is there anywhere else we can put them? And then making a determination about that. And the key is just messaging it the right way at the right time so that you're reserving that flexibility, right? So that you're managing employee expectations, that being granted an exemption doesn't necessarily mean that the process stops there, right? And that there aren't other things that need to be considered and approved. And I think that's really important. I also think, and this is just my hunch, I don't know, right out of the gate, we had a lot of government agencies sort of taking this position that vaccination was the only option for accessing these work sites. What we may see, I have no authority on this, but what we may see is the government walking that back a little bit to kind of maintain the integrity of the mandate. And so I think this is a really good reason to wait to make final decisions on that. So it may be, let's say you figure out today that you have an employee who's exempt. You talk to the government customer, the customer says, well, at this time, effective January 18th, we are not going to allow this position onto our work site if they're not vaccinated. We don't care about exemptions. We don't care what the reason is. My suggestion would be that rather than taking any kind of immediate action in response to that, let the employee know a few things. Number one, that as of right now, it's your understanding that once this mandate comes to enforcement, that they may not be able to work on the customer site. And if that's the case, that is going to impact their continued employment, notwithstanding their exemption status. But right now, you want them to stay the course following your regular health and safety program protocols while you continue evaluating the issue and while you continue monitoring related developments. Now, this needs to be balanced against another tricky piece, which is continuity, right? And so it may be that you're in a position where you can't not perform. The government said you can't not perform on the contract, right? And so you may think to yourself, it takes us 2 months to fill these roles, right? This is a highly technical role or whatever the case. We need to start recruiting. We need to start replacing. And I think you want to be open with your employees about that too, right? And you want to just be, I think transparency is good here. And I think employees appreciate it. And so I think letting employees know, look, we have some continuity concerns here. We can't end up in a position where we don't have anyone staffing this contract. We're going to be as deliberate as possible and not making any final decisions before we have to. But we wanted to let you know we are going to post for this position and we're going to start looking to fill the role. And you should continue working, unless and until we fill the role. And if it looks like we're going to need to make a decision on this, we will let you know as soon as we are able, right? And so just managing expectations. It's a very tricky balance between, protecting your business interests, your operational interests, being able to fulfill your contract, and then not necessarily acting in a way that creates legal risk that a month from now may not come to pass, right? A month from now, your same government customer may say, we've changed our requirements. As long as your employee submits to weekly testing, they can come on site. So it's part of the reason why this whole thing is so challenging, because employers are the ones kind of stuck in the middle, right? The employer, no one's saying, sorry, we know how hard this is for you and you have to make these decisions about what may or may not happen. And oh, by the way, we keep changing the rules every week. Like no one's too concerned about that at the federal government level. And so I think you just have to do the best you can. And if you're in HR and you're advising decision makers, I think the key is to just frame everything as, subject to change, being nimble in your practices and your communications, being flexible to the extent you can, and looking at things holistically, big picture, right? Because certainly legally, there's nothing that prevents an employer from having whatever kind of vaccine policy they want and mandating it as long as you comply with the ADA and Title VII requirements. So it's not that you can't say, if you aren't fully vaccinated by December 15th, you're out. You certainly can do that. It's just a matter of risk tolerance and what your objectives are, looking at it holistically and having a good sense of all those factors, those competing and unaddressed factors, which is confusing and challenging to manage.
It is. I can absolutely agree with that. As far as sharing information, so we kind of touched on government client requirements and those types of things. And I think we'll skip this next question because we're getting close. So we'll skip ahead to this one. I'm just curious if we have a client that's asking us for a list of our employees saying, give me their vaccination status. Is that something that we could share with the government client, or should we be careful with that? Just curious on your advice there.
I've seen it a lot. The guidance makes clear that the government can ask for that information. What I'm really suggesting as a best practice, and I haven't seen any pushback on this from government customers, is that rather than characterizing what the information you're sharing as vaccination status, instead characterizing it, which frankly is technically more accurate, as which employees have verified that they are fully vaccinated, right? And that's a very subtle distinction, but it is a distinction between technically disclosing medical information versus disclosing that the employee has met the requirement that's set forth in the contract. And so I haven't seen any customer push back on that. I think employers probably do need to provide that information because the government is kind of evaluating and planning how to adjust on their own. And so I'm comfortable with employers sharing that. And the same is true in the converse, right? So you wouldn't be saying these 10 employees are not vaccinated. You'd be saying these 10 employees have not verified their vaccination status. Until they do, you don't know if they're vaccinated, right? And so again, you're not making a representation about their medical condition or their medical status. You're making a representation about their compliance with the requirement. And I think that's the best way to handle it. In terms of sharing information about exemptions, perfectly fine to let employers know that customers know that your personnel, certain personnel have been approved for a religious exemption or a medical exemption, but you would not share any details, right? Any information about specific medical conditions or specific religious beliefs. And, it's interesting. We've seen some employers who get some kind of pushback from their government customers on this, where they are really asking for more information or more detail. And I think when that happens, that is, I try not to do these presentations and be like, call us, right? But I do think that's a good situation where if you're in a position where a customer is really pressing for that information, it would be good to check in with counsel and just get their advice on how to best navigate that, because we are certainly seeing that.
Absolutely. Yeah, I think that's great advice. So we touched a little bit on this earlier, but earlier this week, there was a 3-state injunction that's preventing the enforcement of all of these developments. So if we can talk a little more about the legal developments, and kind of the bigger question, which we have on this slide, is what are the chances of this not even going into effect at all?
Yeah, it's interesting because this is another area where employers are really the ones being kind of stuck in the middle because there's so many kind of competing positions and unanswered questions. But to give you the background first, where we're at right now is that we've had, I'm aware of 27 different state challenges in 8 separate federal courts, right? And so those are the current kind of pending challenges. One of those challenges, as Jenna noted, a temporary injunction has been issued, essentially taking the position that the federal government can enforce its vaccine requirements for any employees working at covered contractor locations in Kentucky, Ohio, or Tennessee. And so if you have employees in these locations, no worries if you've already gone through, the verification process or already gone through the accommodation process, but you probably, I would say, do not want to take any adverse action, right, from a compliance standpoint for employees working in those states. There's also 6 that I'm aware of private lawsuits, right, industry groups or private entities that have brought lawsuits or legal challenges to the EO. And then we have things like the newest development in Florida, state law developments, right, where we have this new Florida law that employers that terminate employees for not complying with vaccine policies may be subject to fines, right, and steep fines and other kind of penalties there. And so it's very confusing because, especially from the state law standpoint, there's a lot of good arguments that whether the federal requirements preempt state law is one argument, and then whether, and this is where the contract issue comes into play, whether a state can even legislate on how contractual requirements are upheld is another question. And so I think employers are really in a tough position, especially, for example, in a place like Florida, in terms of deciding like how to proceed. And I think that, again, and I know I'm being a little bit broken record here, but it brings us back to the point where, okay, let's not fire anyone yet who's not in compliance with the policy. Let's wait and see. Let's table it for as long as we can. Because one thing that's not clear, that we're not clear on is this January 18th date going to be further extended? Will we find out in a month that it's now February 18th and we have even more time for some of these things to be resolved? Also not clear, if we have too many more of these state law challenges, if we have courts coming out and saying we're enjoining this on a permanent basis, or then there's going to be litigation with the federal government. Is it possible that the Biden administration will just walk this back to some degree? And maybe they would say something like, Now it's vaccination or testing, similar to the OSHA standard, right? And so I think it really remains to be seen what's going to happen. And based on the briefing schedules I'm seeing, many of these challenges aren't even going to hearing or aren't being fully briefed before mid to late December. So I think we have at least a few more weeks before we can start to get a sense of how this plays out. My opinion, and again, this is just my opinion based on everything I know and have been reading, is I think it's unlikely that these requirements will be taken completely off the table. I think that's unlikely. I think the Biden administration's goal is to make sure that this has as broad an impact as possible in increasing vaccinations in this country. At the same time, interestingly, the administration just announced on Monday that with respect to federal workers, there's not going to be any enforcement of the vaccine requirement before the end of the year. And that's important because that vaccine deadline hit on, I believe, November 22nd, right? So this sort of January 18th deadline that's looming for federal contractors, for federal employees, that deadline passed on November 2nd. So I think it's notable that the administration came out and said, we're going to take at least a month plus before we make any decisions about enforcement. And so I think we're going to learn a lot before January 18th. I think there's a chance that there could be an adjustment to allow for vaccination or testing. But, importantly, I still think my opinion is it's probably best to still be working towards compliance, right? Unless and until we understand that that's no longer required. Because a worst case scenario, I think, for employers is to be in a position where, we learn on January, 5th that everything's going as planned on the 18th. And then we're kind of scrambling when we could have been taking this time to work towards compliance. And I think the key is just separating working towards compliance versus taking adverse or enforcement action while we're waiting to see how this plays out.
Absolutely. So we're getting close to time. So I'm going to go ahead. We actually had a really good question come into the Q&A. I don't think we'll get through all of them, but again, we'll send out some more information if we don't. But you had touched on earlier, I think it was way back in the beginning, of the flow down requirement. So this flows down from contractors to subcontractors. Can we talk a little more about how to flow that requirement down? Is there anything that employers need to be gathering from their subcontractors, or what does that look like?
Yeah, I mean, what it's going to require is a modification of the subcontract, right? And so I think you're going to want to make sure you're working with your contracts folks. And full disclosure, I'm an employment, even though I work with a lot of government contractors, I'm an employment lawyer by training versus a government contracts attorney. But I think that you're going to want to affect it contractually, which means probably modifying your own subcontracts and probably parroting the language that's coming into your covered contracts. And I think that's something that if you haven't started looking at, you also would want to get a handle on. And that goes in both directions. Whether you're the prime or you're the sub, I think you want to have your contracts folks looking at that, getting a handle on how that needs to be facilitated. And really, too, this goes back to the point of making sure you understand what the top line government customer is requiring, right? Have they already modified your contract? Have they indicated they're planning to? Have they indicated they're not planning to anytime soon? So that's an important step in terms of information gathering, just like the information gathering that you're going to want to be doing on where things stand with your employees requesting exemptions or verifying their vaccination status.
Perfect. And I think we might have time for a couple more questions. We had someone ask about dealing with employees, or what do you do with the employees who have submitted an exemption request, it's been denied, and they still are refusing to comply? What can we do after that? And I know we've talked about slow rolling things, so I know there's a bit of wait and see, and we may have touched on it, but I think that would be helpful to cover too.
Sure. So, and this is where I mentioned before how we have some interesting kind of takeaways from the OSHA standard, even though it doesn't apply. And one of those takeaways relates to, how you kind of try to get employees on board or address this situation where you have an employee who doesn't want to comply, because the guidance was updated at some point to make clear that covered contractor employers do not need to proceed directly to enforcement, but instead can undertake counseling and education first. And of course, in classic federal government style, they did not define what that means or what it's supposed to look like, right? But we do know that OSHA also has kind of a similar component, the standard about educating employees. And so, for example, OSHA refers employees to the CDC fact sheet, right? So that would be a reasonable piece of information to provide to your employees. I think also, and this is really where HR people are going to shine, I think just communicating with the employee and making sure you really understand where they're coming from. Now, look, if you've got 300 employees who aren't in compliance or who haven't submitted legitimate, requests, that's going to be a challenge. But let's say let's say at this particular moment you've got 24 employees that either haven't submitted an exemption or have told you they don't intend to comply, or you haven't heard from at all. I think probably one of the most effective things you can do is have some kind of person-to-person contact, right? Reach out to the employee, figure out what their intentions are. Say, hey, look, in there, you can send a broader communication if helpful, just letting employees know, we recognize this deadline's been extended. At this time, we still understand that this requirement's going into effect. As such, we really need to hear from you in terms of your compliance with our policy or any requests for exemptions. And then following up with employees on an individual basis to really try to get that information and understand where they're coming from. Interestingly, I've certainly seen a number of cases where once HR takes a little bit of time to drill down with the employee and connect with the employee, they get some information they didn't otherwise have, right? In terms of what the employee's questions or concerns are. And don't get me wrong, there's a sizable element of the US population that no matter what you say is not going to be convinced that they should be vaccinated or that they're willing to be vaccinated. But I do think there is a segment of the population where there are just legitimate concerns, questions, fears, a lack of understanding. And to the extent you can help clear those things up, either in the context of addressing an exemption request that you can't quite get behind, or just an employee who has been avoiding you, and hasn't verified or has told you they don't intend to comply. I think it can go a long way. And it's a very obviously an individualized approach in terms of how you talk with the employees. But I think one kind of guiding factor that helps employees kind of understand that you're on their side is that no employer wants to be doing this, right? Like no employer wants to be backed into this corner where they say, look, you can't work for us anymore if you don't agree to these decisions about your own body and your own health, right? Like that's not part of the American experience, right? In the workplace, at least, right? Like we try not to do those things. And so I think it can be helpful in terms of getting employees to trust you and to sort of open up to you, to acknowledge that, to say that this is out of your control, right? This is out of the employer's hands. This is something we have to do. We want to work with you. We value you. Let's figure out what's going on here and if this is something that can be resolved.
Yeah, I think that's an excellent point. Just that communication that, look, this wasn't necessarily our decision. It's something we have to comply with, kind of gives a level of understanding there as well. So I think we have time for one more quick question. We did have someone ask about the booster shots. So those are big. We see them all over the news now. And just, I haven't seen anything yet, but curious to see if you've heard anything or seen anything about how this relates to boosters.
I probably haven't seen anything that you all haven't seen. I know we're looking at the same media sites and running the same Google searches, believe me. There's no sort of magic website for the lawyers, I wish. But I think that, I've certainly heard that it's a possibility that the requirement's going to be expanded to include boosters. It certainly has not been done yet. And my sense is the Biden administration at this point probably just wants to get through all these outstanding legal challenges and kind of see where we're at. I think another really interesting thing that could turn the table on this a little bit is we know that, I guess, rates of infection are starting to go up again, right? As we approach the winter months and people are indoors. We have this whole kind of, it's very sensationalized in the media, this new variant, right? That I guess we're not clear on what's going on with that or the impact of that. And so I think we shouldn't underestimate how public health guidance and findings are driving this process and playing into it. But right now, I'm not aware that there's any imminent plan to modify this to address boosters. I would not be shocked if before we get to the 18th, that changes. But I mean, I think the only thing I'm certain of is that nothing is certain, right? Which is just a terrible place to be in when we're dealing with employment law matters and HR matters and employees, right? Certainty is helpful, and we don't really have it, so we can only go on what we have.
I believe that is about all the time we have today. So if we didn't get into any of the questions in the Q&A, feel free to send us an email. We also have a resource slide, and I believe this question came up in the Q&A at one point, but we will be sending out the slides, and we have recorded the presentation. So I just want to say thank you, Kara, so much for spending time with us today. That was amazing advice, great counsel. We appreciate your time. So thank you so much.
It's my pleasure. Thank you for having me.
Thank you. And thank you also to everyone on the call. We appreciate you joining us today, and hope you have a great rest of your week.